The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Please be seated. We are here this afternoon for the submission of 4 cases. The State of Iowa versus BCD is hereby submitted without oral argument. And the case of State of Iowa versus Vita Amici is also hereby submitted without oral argument. Our first case for oral argument is State versus Griffin. It looks like the parties are ready to go. Mr. Rogers.
May it please the court, counsel. I'd like to begin by talking about the reasons that the district court erred in its application of State versus Tyler. I'll talk about State versus Harrison, which interpreted both code provisions that we think were violated here and provided probable cause, 321.37 and 321.38. And from those 2 cases, I think we get a rule that license plate regulations require that license plates be readable. The license plate here wasn't readable, and that's how the district court here erred in applying Tyler. Tyler does say, in context, that the Iowa Code doesn't prohibit tinted license plate covers, but it's talking about the law enforcement officer's belief that all license plate covers are prohibited by 321.37. And where Tyler says that's not the case, that's what it's talking about. And so a tinted license plate cover that precludes a full view or stops a plate from being clearly visible or clearly readable, legible, readable, does violate 321.37 and 321.38 in our view. And the district court also erred in saying that Tyler addressed 321.38, where Tyler said that argument isn't preserved, it's not before us, we're not talking about 321.38, we're talking about 321.37. So we think that with the clarification of Tyler that it doesn't allow every tinted license plate cover, the license plate cover here was unreadable, and Harrison says that 321.37, 321.38, and other provisions governing plates in Iowa require that the plates be readable, and the plate here was not readable. And we have a dash cam video, a still frame from that shows. You can barely even see that there's a plate on the vehicle. And that's when the violation occurred. And defendant talks about clearing up the violation, the officers getting closer, and then when they're bumper to bumper, having pulled the vehicle over, that then it's readable. Well, the violation had already occurred when, from a reasonable vantage point, the officers couldn't read the plate, couldn't see the plate. The language supporting that there's a reasonable vantage point to view the plate from, that it has to be readable from, is the clearly legible, clearly viewable, full view language of the 2 provisions. And without a viewer, there's no visibility. Without a reader, there's no legibility. So what we're talking about, and Harrison says the purpose of these provisions is for law enforcement and for other drivers to identify vehicles when the viewer can't see the plate from a reasonable perspective, we can't read the plate from a reasonable perspective. That is when the violation occurs. So we're talking about a probable cause stop, and the probable cause to stop is based on witnessing the violation.
I mean, I think that you have to be right, that there's this sort of spectrum, right, between 0 tint and 100% tint, right? It's opaque, perfectly clear. And at some point in this range, you can't read it. And with like car windows, I think there's a 70% visibility that light can get through. What's our metric, or how does this court, or how does a district court measure what is too much tint for a license plate cover?
I think the metric is if from a reasonable vantage point, it's not readable, and that's not specific. It's not, you can't do like they do at the car shops or I think law enforcement officers even have them too. They can put some sort of mechanical device up to the window and see what the tint level is. And the problem occurs too, which this case demonstrates, is that the tinted cover allows reading a license plate in the sunshine, whereas it can be completely blacked out when it's in the shade, as was the case here. So I think we have to go based on where's the reasonable vantage point. And a reasonable vantage point here is when the law enforcement officers pull up in the left lane, the car's driving in the right lane. They say, you know, we tried to read it. We're a car length and a half, 2 car lengths behind. We couldn't read it. That's when the violation occurred. A district court applying it.
50-foot rule of thumb.
There are provisions in other parts of the code that provide for 50 feet when the license plate's illuminated. It's not exactly that clear in the language of 32138, 32137. The code requires the big numbers to be visible from 100 feet. Is another thing that we could put on it. But I think from the clearly legible language and from the clearly visible language, it's a relative standard.
A couple times now you've said 321, 27, and 28 and other provisions. I think the very specific provisions, and so I think if you had to pick like the very specific provision, which one would it be with respect to legibility?
Legibility? Well, 38 talks about, has the specific legibility requirement.
It's not just that it has to be legible, period. It just says that it has to be free from foreign materials and in a condition to be clearly legible.
I think the clearly legible, it has to be maintained it has to be maintained free from foreign materials to be clearly legible. It has to be maintained in a condition to be clearly legible. I think the clearly legible modifies both of those.
Interrupt your answer. I just read it as shall be maintained free from foreign materials and in a condition to be clearly legible. Aren't those two things?
That is a fair reading as well. And in a condition to be clearly legible, we don't think it's requiring that it's not scratched, that it's not faded, that it's not dented, affecting legibility. We think the condition is there something in front of it causing it not to be clearly legible? That's its condition as well. Visibility is also another requirement of the statute. And
View 37 to be a lot to do with what I call a beauty ring. They're saying don't put those things around your license plate. And when you look at 38, kind of taken off of what Justice May was just talking about, the word "and" is there, free from foreign material and clearly legible. So just that first part, isn't that whatever plate they put on top of the plate, it's a cover, isn't that a piece of foreign material?
I think it is. I think that is a foreign material, and there are other cases that talk about foreign materials and specifically say that the plate covers are foreign materials. So we think that it's not maintained free from a foreign material when you have the plate cover on it, and so that's another way you could go that it's violating.
Plate? The plastic thing that's covering it, whatever we're talking, is it in the shape of a plate?
So I believe it's
Imitation plate shall not be fastened to the vehicle. That's the last part of 38.
Well, I don't want to make new arguments here. We didn't make that argument. I hadn't thought about that as a possibility.
Is there a difference between visibility and legibility?
I think they're very closely related. I think the visibility is a requirement so that it can be read. And I don't know what other requirement there is that is requiring visibility and not legibility. I think it's a belt and suspenders sort of approach. It has to be visible. It has to be legible.
Scratched or faded or those kind of things, that might go to, you can't read it, if you're even close up, versus visibility seems to be kind of the distancing. Is this a distance? You had mentioned, I think the officer said once they stopped or as they were stopping, then he could read it?
One of them testified that it was, when they were bumper to bumper, they could read it, and then I think the training trooper said he had to walk up to it before he could see it.
Dash cam, I thought, as they were coming up to a stop, though, I thought one of them said, I can read it now, or...
When I watched the video, that's when it started to become clear.
Visibility, kind of back to Justice McDermott's question, if we're talking about a tent that's making it hard to read, that sounds like legibility, but is it because it's not visible because of the difference between being in the shade and in the sunlight? So I'm just trying to determine if there's a difference between visibility and legibility and which one, and maybe it doesn't matter. But my concern, though, is that the statutes are very specific, and I think we need to, it's easy to say plates need to be visible and legible. That sounds like a really great thing, except that's not what the statutes say.
I think the place and position that it has to be visible is a requirement. So that taking us back a year, that so that you don't put it behind a trailer hitch or behind a bike rack. It might be legible if you walk up and look around, but it's not visible there. Where it's legible, I think the tint and some of these plate covers will blur the letters as well. So maybe it is visible, and then when there's the blur on it, then maybe it's not legible. And I think it goes back to what's the vantage point you're looking from, because if you go up and you're an arm's length away from it, that's not what the code is envisioning. I think.
Night, it has to be illuminated so you can see it from 50 feet. At daylight, you ought to be able to see it at 50 feet. That seems a reasonable, logical inference, right?
It does.
What, 3 car lengths or so, something like that?
Or 3 or 4. And we're talking about the legibility and visibility. I don't know if the troopers commented on where it's safe to follow straight behind a car based on your speed. But they said they got up along the left side because they were going too fast to come up right behind it to try to read it.
That it's 5:30 in the afternoon, it's February, so it's basically dusk. It's probably the worst time of the day to see anything, especially if you have eyesight like me. So, what do we make of that?
I think what to make of that is, it's not, once you put it on the car, it's not a violation or not, if that makes sense. The violation can occur later if you drive the tinted with the tinted cover that's viewable in the full sun. If you drive into the night and it's not viewable, if it causes your plate to not be readable when the sun goes down, then that's when the violation occurs. It's not this plate cover is okay and this one isn't. If it covers it sometimes, it's okay. If it allows reading it, sometimes it's okay. If it covers it up.
This plate, you could be driving around in day legally, and if you drive it at night, you're in violation.
The visibility and the legibility, I think so.
Findings made here, I don't recall anything where the district court said, I find that at a distance of 3 car lengths say, this wasn't legible. I thought that the district court kind of jumped straight to the legal issue.
That was my reading as well. The district court really said it's a tinted cover and read Tyler to say all tinted covers are okay. And that's where the district court ended up and said, we're done here effectively.
Man, this, if you're right on the law here,
Remand it to decide, for the district court to decide in the first instance whether it's viewable, whether it's visible. You could, I think probably that's the best course, and depending on the guidance that you give, you could say, from a reasonable perspective, from a reasonable perspective. See, my time's up.
Mr. Murphy.
Justice Christensen, good afternoon. May it please the court. I think the troopers made it very clear the purpose behind the stop. We can hear the troopers narrate into the dash camera. They use the word plate frame. You can hear the major or sergeant major type into his device to look up the code section 321.37. So he's talking about the plate frame being too dark, and he's referring specifically to the code section that discusses plate frames. When they
That, okay.
but when they write,
8, which was also argued down below and mentioned just broadly in the district court order as well, makes reference to 321.38, and that includes that imitation plate thing not being fastened. I'd like for you to comment on that.
I will briefly address 38 if I could finish this point. When we look also to the narratives that they supply in the appendix, they're referring specifically to 321.37. They're making reference to the fact that the printed information on the plate, that they could not view it. And so again, whether it's the video that captures their statements or their narratives in this record, they're referring to 321.37. And so Tyler tells us that that stop based on a plate cover, plate frame, that's a mistake of law. And so to your point, Chief Justice Christensen, about 321.38, I know that the state had a lot of discussion about that. That code section that the officers could also rely on, I grant you that, Justice May, and the district court did discuss it in its ruling, but that covers 3 separate things. One is the positioning of the plate. Okay, the plate has to be in a position to be clearly visible. So the discussion about visibility is in the context of the position of the plate, where it is on the car, how far it is off the ground, is it horizontal, is it fixed in a position. So visibility goes to positioning. Legibility goes to the condition of the plate. Other cases by the Court of Appeals that have talked about scratched, dented, rusted, faded plates, that's really talking about the legibility of the plate. And so I think that we've already got case law that covers the legibility. It's not necessarily how far the troopers should be able to read the plate. The one part that I haven't discussed is the foreign materials. Now, I think we need to be clear about that. Tyler addressed foreign materials in the opinion. And if you recall, that plate had even though the officer referred to it as a tinted cover, I think the district court made a factual finding, or maybe this court made a finding that it was in fact a clear license plate cover.
Fact question. So in your brief, I think your position is the officers pulled the defendant over because the plate was tinted. Is that right?
Based on what they said in the video and what they put in their narrative report, they're referring to the plate frame being too dark. So I believe that they pulled him over for a tinted license plate cover.
Is I could not see the plate. It was not clearly legible. I was unable to provide letters or numbers to Trooper Nguyen. It was very difficult just to see the big letters and numbers to the point where we couldn't even read it legibly. So if the basis for the stop factually was the inability to read the letters, does that distinguish Tyler? Or does your argument really depend on the factual assertion that the reason for the stop was the plate versus the legibility?
At some point, as the troopers are stopping the vehicle, that they can read everything on the plate. And by everything, I mean the state of Iowa, the county, the printed numbers and letters, the registration sticker. They could see everything from that point. Now, could that have been seen from 50 feet or more? I don't think that there's been any finding from the district court about that.
When was it that they could read it so clearly?
Point of time where they are not quite yet stopped. You can hear Sergeant Major clearly say on the dash camera audio, "Oh, there it is, I can see it." And I think that they acknowledge that in the testimony.
Testimony, though, from the other trooper, I forget his name, the leader, that he couldn't read it until he was up close. He got out of the car and went up there and looked at it.
The same trooper that's narrating while they're in the car. So to the extent his trial testimony, his suppression hearing testimony becomes, I couldn't see it until I'm right up by the bumper, I think that that would be inconsistent with what we hear on the audio.
Didn't he testify that he couldn't read it well until they got up just next to it? Isn't that right?
Roadway, I believe that he could not read from their position in the left lane to where Mr. Griffin's vehicle was in the right lane when they were discussing what code sections apply. I think he did indicate at that point he could not read it.
About the testimony where he says that he had to get out of the vehicle and be up right next to the plate to be able to...
I don't credit that when you compare it to what he's actually narrating into the audio when he's still in the vehicle. He says there...
Could read the numbers?
As I can see it.
Yeah, but did you hear what I asked, though, about the reading? Did he say that he could read the numbers on that video?
He does not say that he could read the numbers or the letters on the video. He just says, there it is, I can see it. From that, I infer that he could read it at that point.
With me that 321.38 is about the ability of a plate to be seen and read while it's moving.
Important part of the section, yes. I mean, obviously, the law is such that we don't want anything that's going to obscure the plate to prevent officers from being able to read it.
Mr. Murphy, I was on Tyler, and that case was kind of a notorious case. It was viewed as a racial profiling case. I think the NAACP got involved with it. And I recall that we examined the record on the court very closely and just concluded that the license plate, it didn't have a tinted cover in terms of tint. It was very legible, and that there was really no basis for the stop. I don't read when Tyler says tinted license plates are not a violation of Iowa law. I think they're not per se a violation of Iowa law is what we meant. I don't think if it's tinted so much that you can't read it, that it complies with Iowa law. Is that your position, that you can, any amount of tint and it's still okay?
Position, and I do read Tyler the same way. Obviously, the officer in Tyler called it in as a tinted plate. The court, whether it was the district court or this court, made a finding that it was not tinted, it was clear. But Tyler goes on to say, and this addresses the foreign materials part of 321.38, Tyler goes on to say that this is not foreign, we don't see any foreign materials on the plate. And I think that there's if we look at other cases, what we're really talking about is road grime, dust, dirt, snow. But
what if we just go back to 37? I guess I don't give up on 37, which is what the officers relied on. A frame over the registration plate, a tinted license plate frame is a frame, which does not permit full view of all numerals and letters. And it didn't unless you were close
Well, like in Tyler, there was, if you recall, there were photographs offered of what the license plate looked like with the cover attached to it, which is why I think the record shows Exhibit B from the suppression hearing, where we can see what's behind that cover. And there's nothing that prevents anyone from that distance from seeing any of the information that's required on the printed plate. The legislature has done nothing with 37 since Tyler. And so to the extent that this court was saying that at that time that tinted license plates are not a violation of 321.37, the legislature hasn't come back around and said, well, we do think it's a violation, so we're going to insert a tint limit on the plate cover.
Photograph of the truck relevant?
Because the officers were describing to the court this very, very dark cover, almost to the point, and I think that there is some testimony where one of the troopers indicated that he didn't even know if there was a license plate there. And so...
Is it relevant only to the extent you think it establishes that the officers were not being truthful in the car?
A credibility of the officers, but I think if the testimony is going to be that there was a point in time where we didn't know if there was a plate at all, that photograph clearly shows that there's a plate that can be read through the lightly tinted plate cover.
A stipulation, though, at the hearing about the fact that this was a different time, different lighting, did not really go to what was seeable or seen at the time of the stop.
Not meant to be a recreation of the what the troopers could have viewed at that point on the road. I was not...
We did have an exact recreation. They recreated it under the same lighting, same conditions, same time. We looked at it as a court and we said, that's legible. This is different. And plus, you know, we can see the dash cam as well, and you can see that it's difficult to make out a license plate on the car.
I agree with you about the poor quality of the video, and it goes well beyond just what is viewable on the license plate. If you watch that from beginning to the point in time where the officers start to engage Mr. Griffin, when they are driving, there are these large interstate signs, and you can see most of the information on there, but there are things such as the specific highway that even when you're right up to it, and I'm referring to the view of the dash cam, when it's right near these signs, you can't tell what the highway is on those signs. And when he has Mr. Griffin's vehicle pulled over, I don't know if it's a Tahoe. I know now it's a Suburban because I introduced Exhibit B. Unless you're from the state of Iowa, you cannot recognize the bright yellow Hawkeye sticker that's on the back of that. The quality of the video is deceiving. So I think that Exhibit B is much more representative of what can be seen at 20 feet than that video.
In the middle of the day, right? And the conditions were not the same as the road conditions, whereas in Tyler, there was a recreation that exactly mirrored the conditions when Tyler was pulled over.
I'd concede that it was not designed to be a recreation, and the troopers were faced with an issue that you can see that hill is blocking some of the sun. It is shaded for an extended period of time.
Redirect you. I tried to talk about it with the state, and they said we didn't argue that. I brought it up with you, and you wanted to keep talking about 37. I'm going back to 38. 37 was, I think, about 30 years earlier than 38. I know there's a bit of time between the two. 37 seems to be a rifle approach to me. It's pretty simple. It's just two lines. It says you have to have full view of the numbers and letters, and I kind of always thought of it as having to do with the frame. Then 38 gets pretty broad. And it says you know, free from foreign materials. You've talked about that. You still have not talked about an imitation plate. It's my understanding from this record that it is a plate cover. So it's the shape of a plate. It has tint to it. It makes it look different. It changes. Why should a trooper or anybody else have to strain to see it? That tint apparently made it harder to see. So how does that not fall under the final subsection of 38?
Imitation plate at all. I think an imitation plate is some vanity thing that you might buy at a gas station or
Colored plate over a plate as being vanity. It's changing the plate.
plate frame that could go around that could say University of Michigan But the plate cover that you're describing, there's no information on that piece of plastic that is attempting to give different numerals and letters, state, county. It's just a cover. It's not an imitation plate.
Also say that the tint wasn't bad enough that it's a problem. But am I correct that whatever was put on the plate is the shape of a plate?
Of the plate, absolutely.
It has color added to it.
To be a slight amount of tint added to it.
Fastened to the vehicle.
Do you agree that a tinted plate could be a violation of 321.38?
I think that if it prevented full view of the numerals and letters, the state, the county,
The only question here then, sort of, was this too much tint? I mean, isn't that a factual finding that we just have to figure out? If everyone agrees that it could be a violation of subsection 38?
I don't know if it's a factual question to the extent that Tyler's already said that tinted plate frames are not a violation of that subsection, and they cite that section and they use the language from the section in their narrative as a reason pulled over. I still think it's a mistake of law. And so if we get into were the officers mistaken about what they could read to turn this into a mistake of fact, I don't think that that would be appropriate. I think Tyler controls it.
Can I ask a follow-up? I want to make sure I understand your argument. So in response to Justice McDermott, you said there's some point where the tint can be so severe that it would result in a violation of 38 because the letters are not legible, correct?
But because then you are, if you can't read the plate, then yes.
If the officer testifies, I could not see the plate, it was not clearly legible, I was unable to provide letters and numbers. If we credit that as true, then the officer perceived or had probable cause to believe there was a violation, correct?
Against all the other evidence that's in the record.
True, then there is probable cause, right?
The only thing that would stand against that would be the language in Tyler. And I think it's important to note, too, that apparently the DPS Academy is not teaching its new troopers anything about Tyler. When he was questioned about that, he had no idea about that case. I would think if there was a law that said that plate covers or tinted covers are not a violation, because that's the language that Tyler uses, the State Patrol is not instructing rookie troopers as to that. And it seemed to be an educational stop. Like there's no safety issue. I asked the officers, couldn't you have waited until you got to the stop sign at the bottom of the ramp to see if it was readable? Did you have to pull the vehicle over right then and there? But even when they do, it is legible at that point. And I realize I'm a little bit over my time, and Chief Justice, if I could make one other point.
It's real short.
We did add State versus Coleman as an issue in this case, and I think that it's important to keep in mind the officers were discussing what they were going to do at the end of this stop, and one of them says to the other, I think we should go up and give him a warning. And what I would ask this court to do is, what is he giving him a warning about? He can't cite him for anything.
Let me ask you, though, again. We agreed earlier that these 321.38, for example, could be violated if it's not visible and legible when you're moving, right?
I think as I drove over here, I looked at vehicles from 50 feet, 100 feet. I couldn't read plates from that distance. And so there is a distance, yes, but the statute doesn't deal with that.
Say, you have to prevent your plate from swinging, and I don't think that plates swing very often when they're at a dead stop. But didn't we agree earlier? Don't you think that we have to decide this based on a moving vehicle? Or are you trying to say that the violation can only occur when it's based on what it looks like when it's sitting still?
And they eventually pull the car over, and in the course of that stop sequence, they notice that they can read everything. That's Mr. Griffin's position, that the troopers could read that. At that point, if they can read everything, there's no basis to go up and engage him. And I know that there's some language in State versus Coleman, that talks about a choice that the officers can make, a wave, maybe they can announce something from the back of the car, or go up and engage the driver. There's a couple of issues with that. One is, if you watch from the videotape, there is an investigation that continues to unfold. The officers put a palm print on the back of the lens to the brake light. They go up, and you can tell from the narrative report, they ask for license, they ask for registration. They walk around to see if there's a front plate. It's not until well into that do they then discover any other information to expand the scope. So if the purpose is to go up and simply to issue a warning, authority where I don't find anything in 321 that gives them, or in 805, that gives them the authority to issue a warning in lieu of a citation, you're inviting law enforcement, when the stop should end, you're inviting law enforcement to then continue it. Thank you.
Back to Mr. Rogers.
I think the Law Enforcement Academy doesn't teach that Tyler says all tinted covers are a violation, because all tinted covers are not a violation, and Tyler doesn't say that. Exhibit B was, as noted, was taken later. It was taken in different conditions, it was taken in a different location. It was taken with a pocket supercomputer. So is it really a photo, or is it a computer graphic with algorithms clearing it up? To the imitation plate,
I do agree that when you're watching the video of the dash cam, I noticed that there were signs, green signs along the highway that I couldn't read either. So do we have an issue with the dash cam? Which I think then probably takes us back to the officer's testimony. So we don't, that might not get us very far, but I think it is hard to tell from that dash cam.
cam pulls one way, weekly, the exhibit B pulls the other way. So I think we are left with the officer's testimony, and I think that's what we rely on for traffic violations a lot.
We're on de novo review. Can't we credit or discredit the officer's testimony ourselves and decide this now?
A review, it's your prerogative. I think you can. I think it's just a jurisprudential decision. Do you want to remand it instead? But to the imitation plate issue, Chief Justice, that you're bringing up, as a former law clerk turned appeals lawyer, I want to go on Westlaw, and I want to look it up, and I want to before I shoot from the hip on the imitation plate. But for a plate cover that looks the same and is making it darker, it's making it, it's kind of blurring the letters.
From another view, maybe expressed, I'm.
I would like to hear what he had.
Oh, sure, go ahead.
I think when it's got this blurred view of the plate and it's making the plate different, you could say that that's an imitation of a plate. I think is a fair reading of that provision.
It's an imitation plate. What I think of is, I used to work on Capitol Hill like 40 years ago, and they had this vanity plate you could buy if you were a staff member there that said U.S. Congress staff, and it really didn't get you anything, but it made you think you were important in D.C., and you would put it on your car, and lots of people had it. And that's what I think of as an imitation plate. It's something that's not a real legal license plate, but it might look like one. Doesn't that make more sense?
Like for a state where you don't have to have a front plate if you're putting on something that's for fun.
People would hang it below their regular plate is what would happen too back then.
I think it may cover, it may also cover stolen license plates or license plates that you're trying to get, to get by with that are not legitimate. The format
About the timing of when the plate becomes legible. Is it your position then, when the officer is moving behind the moving car and can't read it, at that point, the violation's complete, and it doesn't matter what happens afterward, right? Is that kind of the state's position? Like,
That's
if you
when,
saw a car speeding, and you said, okay, you're speeding, and now we're stopped and you're no longer speeding. I mean, the violation doesn't go away. Is that kind of what you're arguing?
Kind of different from Coleman, so, you know, I dissented in Coleman, but I still think that's different. So that was where the motorist was believed to be, I think, had a suspended driving while barred. And it was like, the owner of the vehicle didn't have valid license privileges, and it was like the owner was a male, and then he got up close and you realized the person driving's a female. So clearly that's not the right person. So we said, let him go, because you've now cleared up, there's clearly no violation. Whereas here, if the license plate's not legible until you get really close, it may or may still may be a violation. That's what we're gonna talk about and address among ourselves, but it is a different case, right?
and we'd ask you to reverse the ruling on the motion to suppress and remand.
Thank you. The case of State versus Griffin is hereby submitted. We'll have a little bit of a pause before State versus TJW.